Good afternoon. Welcome to our webinar today on HIPAA privacy and security rules, training for covered entities. My name is Kim Stanger. I'm the head of our firm's health law group, and I practice a lot in the area of HIPAA as well as other healthcare issues. HIPAA is one of my favorite topics. In talking with a lot of our clients, they didn't have very good cost-effective training for their employees. So we thought, well, okay, maybe we can do a webinar series that we could provide to our clients and our friends that you could download and use for training. So that's the purpose of this webinar today. It's going to provide an overview of the HIPAA privacy and security rules along with the breach notification rules. It's really designed so that you could use that to train your office staff or your hospital staff, a cost-effective way to provide training that's required by HIPAA. This is an overview of the more significant rules. We're going to try to cover everything in roughly an hour. We may go a little bit over, so we're not going to be able to go through everything, but it'll give a good background, a good basic understanding of HIPAA, especially for those people who are on the front lines. For those of you who are staff, if you have more specific questions when a HIPAA issue comes up, make sure that you check with your organization's privacy officer. If you're a privacy officer, make sure you know the HIPAA regulations and your own state law to the extent that that's more restrictive than HIPAA. As far as the written materials, we provided you with a copy of the PowerPoint presentations along with an article I authored on complying with HIPAA, a checklist for covered entities. We've also given you a sample notice of privacy practices, which is really a pretty good shorthand way to, if you want a refresher concerning the HIPAA requirements, most of that should be set forth in your notice of privacy practices. This presentation will be recorded and is available for download at our website. If you have any questions as we go throughout the program, feel free to use that chat function or shoot me a quick email after the program, and I'll see if I can, or try to respond as quickly as I can. Given the amount of material we've got to cover, we probably won't take questions during the program, but I'll follow up with you afterwards. With that said, let's talk about HIPAA. HIPAA is short for the Health Insurance Portability and Accountability Act of 1996. Note that it's HIPAA, not HIPPA. It's found at 45 CFR 164, and it's comprised of the privacy rule, which applies to the protection of any protected health information. It's also part of HIPAA is the security rule, which applies to the protection of electronic protected health information. And then there's also the breach notification rule that requires you to notify covered individuals and the government in the case of certain breaches. In addition to HIPAA, sometimes you hear about the HITECH Act. The HITECH Act came out as part of the economic stimulus package, and it really beefed up HIPAA and expanded the reach of HIPAA. The HITECH Act implemented a bunch of statutes, but we had to wait for the implementing regulations to come out. Those generally were issued in January 2013 as part of the HIPAA Omnibus Rule. So if you're wondering what that Omnibus Rule, the Omnibus Rule is the rule that kind of took all those HITECH Act amendments and rolled it all into one. So pretty much we now have the complete HIPAA. Remember that HIPAA now establishes the floor of patient privacy. To the extent that there are other laws that are more restrictive than HIPAA or that give patients greater rights concerning their information, then you got to comply with that other law. So it may be that your particular state law may have more restrictive laws, and therefore if that's the case, then you would need to comply with your state law. For example, 42 CFR Part 2 applies to disclosure of certain information concerning federally funded drug and alcohol treatment programs. That provides in some ways some requirements that are more strict than HIPAA. So you have to look at the requirements for both HIPAA and 42 CFR Part 2 to make sure that you're complying with the more restrictive law. So I like to start when you're talking to staff, what's the big deal about HIPAA? I mean, why do these patients even care about this stuff? Aren't they just going overboard with all of this? In order to understand this, or for staff to understand that, you have to turn it around and you have to ask yourself, well, how would you feel if you learned that your staff at your doctor's office gossiped about your medical condition, or your doctor's office posted your medical information on Facebook, or shared your medical information with your employer, or you found out that a local hospital lost a laptop that contained your unencrypted information, including your Social Security number, your account information, your insurance information, your medical information, In those situations, you might be a little bit miffed. Well, that's what HIPAA is designed to protect against. And if that's not enough to convince you to take HIPAA seriously, you need to do it because of the civil penalties can be imposed. The penalties under HIPAA can range from anywhere from $100 to $50,000 per violation, depending upon the type of conduct that's involved. The important thing here is that if you act with willful neglect, it's a mandatory fine of at least $10,000 to $50,000 per violation. If you act with willful neglect but don't correct it within 30 days, then it's a mandatory fine of at least $50,000 per violation. You see, when the government first came out with HIPAA, it seemed like they really weren't enforcing it. And so the privacy advocates got involved, and as part of the HITECH Act, they ratcheted up the penalties and made the penalties mandatory if you act with willful neglect. You don't want to go anywhere near acting with willful neglect. So we're going to talk about the things you need today to ensure that you're not acting with willful neglect. Now, the good news is if you don't act with willful neglect, you can still get hit up with penalties of $100 to $50,000 per violation, but there is no penalty if you correct the situation within 30 days. So what you want to do is make sure you're not acting with willful neglect, and if there is a privacy breach or a violation, that you correct it within 30 days in order to mitigate your potential damages or avoid fines altogether. Now, those penalties can add up awfully quickly if there is a violation. Because, for example, if you lose a laptop that contains 200 patients' names or 2,000 patients' names, that's 2,000 different violations. In addition, if the violation is such that you did not have a required policy in place, every day you fail to have that policy in place, that is an additional violation or a separate violation. That means since HIPAA's been out since 2002 or 2003, that is a lot of violations. And therefore, you need to make sure that you comply with the HIPAA rules. You look at the HIPAA settlements in the past year. These are the ones that are published on the OIG's website. I mean, they range anywhere from, what, $125,000 up to $3.5 million. Interestingly enough, or significantly, most of the violations that we're seeing come out now are a violation of the security rule. It's situations where people have not put in place the protections for electronic protected health information. Those are the ones you've really got to be concerned about, because if you're going to have a breach of electronic protected health information, it's probably going to involve multiple patients, multiple parties, and therefore it can result in those multiple violations and multiple penalties. So in the past, people didn't take the HIPAA security rule very seriously. Those days are over. You need to make sure that you're complying with the HIPAA security rules. In addition to the civil penalties, if you're really a bad actor, you can actually go to jail for a HIPAA violation. Under the criminal penalties, they apply if employees or other individuals obtain or disclose protected health information from a covered entity without authorization. The penalties are anywhere from $50,000 fine up to a year in prison to $250,000 fine and 10 years in prison if you do it with intent to sell, transfer, or use for commercial gain, personal gain, or malicious harm. Now, you may say, well, the government would never enforce that. Au contraire, they have. You may remember a few years ago there was a tragic case where a newscaster in Little Rock, Arkansas was murdered in her apartment. Before she died, she was taken to the hospital. It was all over the local news channels, and one of the physicians at the local hospital decided just to log on to see what was going on. So he logged on the computer system just to look at the medical records. He didn't have a reason to do that. He was just curious, but he wasn't selling the information anywhere. He was just curious. Well, guess what? That's a HIPAA violation. That physician got a $5,000 fine and a year probation. Two other employees that did kind of the same thing, they also got fines and probations. There's been other situations where people have gone to jail for snooping for up to 6 months and had to pay significant fines and penalties. So even if you are not a covered entity under HIPAA, maybe you're an employee, you're not a nurse, you're not a clinician, you may not be a covered entity, you may still be subject to HIPAA criminal penalties if you violate the HIPAA rules. What are some additional reasons to comply? Well, you not only have to worry about the feds, because under HIPAA, state attorney generals can bring lawsuits in which they can recover $25,000 fine per violation plus recover their fees and costs. Some of the largest HIPAA fines to date
have been actually recovered by state attorneys instead of the Federal Office for Civil Rights, which is the HIPAA police. In addition, under the HITECH Act, patients can recover a percentage of those fines. Now, we don't have the implementing rules on that yet. We're waiting for those implementing regulations, but when they come out, those patients whom you share their information improperly, if they can turn you in and recover a percentage of those fines, so they can become bounty hunters, and it increases the incentive that they're going to turn you in. So it raises the stakes for HIPAA compliance. There is no private cause of action under HIPAA. They can't sue you per se for a HIPAA violation. However, HIPAA may effectively become the standard of care, and so patients, creative plaintiffs' lawyers out there are using HIPAA kind of as the standard of care, or under a negligence per se argument, to sue people for effectively HIPAA violations. Even if you're not worried about anybody else coming after you, you have to be concerned about your own job, because under HIPAA, a covered entity must impose sanctions against a workforce member who violates HIPAA. If they fail to do so, that covered entity is itself violating HIPAA. HHS is also conducting audits. Maybe you haven't been hit by HIPAA yet, but there's a possibility, although a small possibility, that you may be subject to future audits by HHS. And even if you're not worried about any of those other situations, you have an affirmative obligation to narc on yourself. You have to self-report breaches of unsecured protected health information to affected individuals, to HHS, and sometimes to local media. We'll talk about that a little bit later. The bottom line is, when it comes to HIPAA, it's simply better to comply. So let's talk about HIPAA and what you need to do to comply. First of all, who and what does it cover? HIPAA only applies to covered entities. It doesn't apply to everybody. It only applies to covered entities. Covered entities are healthcare providers, but not all healthcare providers. It's only those healthcare providers who engage in certain electronic transactions. Those electronic transactions generally deal with submission of claims, data to third-party payers through electronic means, and similar types of arrangements. If you are a purely paper healthcare provider, you don't engage in any electronic transactions, you can avoid HIPAA. But that's very rare these days, so it's going to apply to virtually all healthcare providers. It also applies to health plans, including employee group health plans if you have 50 or more participants or administered by a third party. That means that most of you, even if you're not a HIPAA-covered entity as a healthcare provider, most of you probably work for entities that have an employee group health plan that either has 50 or more participants or that's administered by a third party. If that's the case, that employee health plan is also a covered entity, and it's got to comply with HIPAA. We're not going to focus on that too much. We're really going to focus on the healthcare provider issues. HIPAA also applies to healthcare clearinghouses, and in the wake of HITECH and the Omnibus Rule, HIPAA now applies directly to business associates of covered entities. We'll talk about that a little bit later. Well, that's who it applies to. What does it apply to? It applies to protected health information. Protected health information is individually identifiable health information that can be used to reasonably identify the individual. It's their name, it's the fact that the person is a patient, it's any information that might reasonably identify the individual. Just simply using that individual's initials or disclosing information that somebody else could use to identify the person, that is protected health information, even if you don't use their name. That information has to concern their physical or mental health, health care, or payment for their health care. So it's not just the medical record, it's also payment records. It has to be created or received by a covered entity, and it's maintained in any form or medium. It could be oral, could be paper, could be electronic, videos, photos, images, etc. Any individually identifiable health information concerning a patient's health, care, or payment created or received by a covered entity. That's what it applies to. Well, what kind of actions does it apply to? Well, certainly it applies to the unauthorized disclosure outside the covered entity, but it also applies to even your unauthorized use within the covered entity. If you don't have a need to know or a need to access it, you shouldn't be accessing it. Otherwise, it's a HIPAA violation. Let's talk about the use and disclosure rules under the privacy rules. HIPAA really, about 80% or 90% of HIPAA can be summarized in this slide, and that says you cannot use or disclose protected health information unless you fit within one of these exceptions. So you can't use or disclose protected health information unless it's for purposes of treatment, payment, or healthcare operations, or it's for disclosures to family members or others who are involved in the patient's care or payment for their care, so long as the patient has not objected, the disclosure is appropriate under the circumstances, and you limit the disclosure to the scope of the person's involvement in the patient's health care or payment for their care. Or you can make disclosures without the patient's authorization for certain public safety or government purposes that are listed in 45 CFR 164.512. For everything else, you generally have to have a valid written authorization signed by the patient or the personal representative, and that authorization has to comply with requirements in 45 CFR 164.508. All right, let's talk about each one of those. Most importantly, HIPAA says the consent is implied if the use or disclosure is for treatment, payment, or healthcare operations. That means you don't need the patient's authorization as long as your use or disclosure is for purposes of treatment, payment, or healthcare operations. There are limited exceptions, particularly for psychotherapy notes. We'll talk about that later. Psychotherapy notes get special protection. For psychotherapy notes, you generally need the patient's authorization, even if it's for purposes of treatment, payment, or healthcare operations. But in general, as long as your use or disclosure is for treatment, payment, or healthcare operations, you don't need the patient's consent. Now, you may think, well, I'm really into privacy, and therefore we're going to get the patient's consent anyway. If you do, if you agree with the patient that you're going to limit your use or disclosure, for example, even though HIPAA would allow you to make disclosures for purposes of treatment to other healthcare providers, but if you tell the patient, hey, we won't disclose this information to anybody without your consent, well, then you better darn well live up to that. Because the rule says if you agree with the patient to limit your use or disclosure for treatment, payment, or healthcare operations, you must abide by that agreement except in emergency. Now, my question is, why in the world would you ever want to agree to that? Because you're just imposing more liability on yourself. So never agree to those types of situations. Never agree to limit your use or disclosure of information for purposes of treatment, payment, or healthcare operations. So a lot of the clients, sometimes they'll have a form. Patient comes in, you say, identify all those people that we can disclose information to, and we won't disclose information to everybody else or anybody else without your written authorization. Be careful about those forms, because I bet you that form says nothing about collection agencies or maybe other healthcare providers or the like. But by asking that or giving them that form, maybe you're limiting your ability to use or disclose the information, even though HIPAA would say you don't need the patient's authorization to do that. So be careful about unintentionally limiting your ability to use or disclose the information for purposes of treatment, payment, or healthcare operations. So that's the first exception. Second exception, HIPAA says you may use or disclose information to family or others involved in the patient's care or payment for their care if certain conditions are met. You don't need the patient's authorization to disclose to family members or others involved in the patient's care or payment for their care so long as you satisfy these conditions. If the patient's present, you may disclose the information if the patient agrees to the disclosure or has a chance to object and does not object, and you otherwise believe it's reasonable to infer that the agreement that the patient doesn't object from the circumstances. So, for example, a patient comes into the exam room with their significant other. The patient's talking to you candidly and freely in front of that significant other. You could probably assume that it's okay for you to discuss that information with the patient even though the significant other is there. If the patient's unable to agree, either because the patient's not present or maybe because the patient's incompetent or unconscious, you may disclose if the patient has not objected on a prior occasion, so they never told you, hey, don't disclose this information to my family, and you otherwise determine that it's in the best interest of the patient. Now, if you're going to disclose that information, if it allows you, you still have to limit the scope of the information to the scope of that person's involvement. So if that person's involved in making the payment for that particular patient, then you can disclose information relevant to making that payment, but you shouldn't disclose necessarily everything. In the wake of the Omnibus Rule, this rule also applies after the patient is deceased. So after the patient is dead, you can still make disclosures to family members or others who are involved in the patient's care or payment prior to the patient's death, so long as the patient didn't tell you otherwise prior to their death. All right, the third exception is in 45 CFR 164.512. They give you a whole list of situations where you can disclose information without the patient's authorization. Most of these are all in the context of public safety or government functions. Things like you can make a disclosure to the extent it's necessary to avoid a serious and imminent threat of harm. So if you see a patient who's under the influence of medication, goes out and gets in their car, hits a couple of other cars on the way out of the parking lot, this would allow you to call the police and disclose that, that this patient has an issue, or you can disclose protected health information as necessary to eliminate that serious and imminent threat. You can also make disclosures to the extent another law requires a disclosure. So, for example, if you're in a state that requires you to make disclosures of certain types of communicable diseases or certain injury for certain types of wounds, gunshot wounds, or treatment victim of a crime, then if that other law requires a disclosure, you can make that disclosure under HIPAA. Just make sure you limit the disclosure to the extent required by that other law. You can make the disclosures pursuant to a court order, warrant, or subpoena. If the judge signs it, then you can go ahead and do it. The judge is the law, and you'll be okay. Just limit the scope of that disclosure to whatever is set forth in that warrant or court order. On the other hand, if it's a subpoena just signed by another attorney, you can't just produce the information. You've got to take some additional steps to make sure that the patient is informed about that subpoena and is given a chance to object before you go ahead and make the disclosure. You can make the disclosure for certain types of public health activities, again, for certain types of disease reporting, abuse, neglect, those situations. You can make reports for certain health oversight activities, like to the Board of Medicine, the Office of Inspector General, or other situations like that, as long as you comply with the specific requirements in the rule. You can make disclosures to the extent allowed by state workers' compensation laws, to coroners, to persons in, law enforcement, for persons in custody, for certain military purposes. The key here is that for all of these exceptions, there are certain conditions and terms that go along with those disclosures. If you're a staff member, before you make those disclosures, you're going to want to touch base with your privacy officer to make sure that those circumstances have been satisfied. If you're a privacy officer, you're going to want to pull up 42 CFR 164.512. Just make sure that all the conditions have been satisfied before you make disclosures pursuant to those exceptions. Okay? So, brief recap. As long as the disclosures for treatment, payment, or healthcare operations, you don't need the patient's authorization unless you've agreed otherwise. Don't agree otherwise. If the disclosure is to family members or others involved in the patient's care, you can generally make that disclosure so long as the patient hasn't objected and you otherwise think it's reasonable. You can make those disclosures for certain public safety or health purposes as long as you satisfy those requirements. For everything else, you generally need the patient's written authorization. And that written authorization has to satisfy certain requirements. It's got to contain the elements in 45 CFR 164.508. including things like it's got to specify who can make the disclosure, to whom the information is going to be disclosed, what's the purpose of the disclosure, it's got to have an expiration date or event, and it's got to contain certain statements like that the provider can't condition treatment on the provision of the authorization with certain exceptions, that additional disclosures may not be covered by HIPAA, and things like that. Now, you've probably got in your organization a HIPAA authorization. Those have a tendency to morph over time. What you may want to do is pull up the regulations and periodically check your authorization form against the regulations to make sure they comply. Alternatively, you can email me and I'll send you a checklist that I've got for HIPAA authorizations if you want to evaluate whether your authorization is compliant. Now, there are certain uses or disclosures require an authorization even though you may think they're for treatment, payment, or healthcare operations. As I mentioned, psychotherapy notes get special protection. Now, psychotherapy notes aren't all mental health records. Psychotherapy notes is a very defined, limited type of record. It's basically the notes from those individual psychotherapy sessions. It's not, necessarily progress notes or overall diagnosis or prescriptions or those types of things. Psychotherapy notes, you generally need the patient's authorization to use or disclose them even for treatment, payment, or healthcare operations, except that the maker of that note can use it for his own treatment purposes. If you're going to engage in marketing and use protected health information for marketing purposes, you generally need an authorization. If you're getting paid by another to make those marketing disclosures, for example, if you're getting paid by some vendor to contact your patients to promote the vendor's items or services, and if you're getting paid for it, you have to get an authorization from the patient, and that authorization has to disclose that you're getting paid to make those disclosures. If you're going to sell the protected health information, you've got to get the patient's authorization in advance. All right, that's the general rules for use and disclosure of protected health information. Now, remember that even though HIPAA would allow you to make disclosures to family members or to another healthcare provider for treatment purposes, HIPAA doesn't require you to do that. It just says that you may do it. You're generally not required to make disclosures under HIPAA, with a couple of exceptions. You are required to make disclosures pursuant to an appropriate request from the patient or their personal representative, subject to certain limitations. If you get a court order or warrant, then you better comply with it as long as you jump through the right hoops. Otherwise, you could get hit up with contempt sanctions. Or if you're required to make the disclosure by other laws, there's that exception under HIPAA that allows you to do it, and you may be subject to the other laws if you fail to make the required disclosure. HIPAA says, okay, even if you can make the disclosure, we want you to take reasonable steps to verify the identity of the person to whom you are making the disclosure if you don't know them. So you need to verify that they are who they are and that they are entitled to have the information. Now, what kind of steps? Does that require some kind of a blood test? No. All you got to do is take reasonable steps. So if the police comes in and says, hey, we want this information, and they otherwise fit within an exception, you may want to ask for the badge. If the OIG shows up, then you may want to ask for their papers confirming that they are who they are. If the mother calls in and wants information about little Johnny, you may want to verify that mom is the mom by asking things like, okay, what's Johnny's birth date, or what's Johnny's social security number, something like that. In addition, to the extent that disclosure is predicated on obtaining certain documents or representations, like from law enforcement, then you got to make sure you obtain those documents or representations. In addition, HIPAA says that even if you're allowed to make these disclosures, you can't disclose more than the minimally necessary amount for the purpose. So if you need to make that disclosure for purposes of payment, you don't need the patient's authorization for that, but you should only disclose the minimum necessary for making that payment or obtaining that payment, not more. Now, that minimally necessary standard does not apply to disclosures to the patient, to another provider for treatment. So if another provider says we need your entire medical record, you don't have to second guess them. And it doesn't apply to requests from the individual's authorization. You can provide the information that the individual states in their authorization. The minimum necessary standard specifically requires that you have written policies setting forth role-based access. So you're supposed to identify the types of employees you've got in your organization and what information those employees can access. So if you're in a physician's office, maybe the physician can access all the patient's records. If it's the billers, however, the billers can only access certain information relative to billing. That's the general idea. Let's talk about personal representatives. Under HIPAA, you must treat a personal representative as if they were the patient. That means that personal representative generally has the right to exercise any of the patient rights that we're going to talk about in a little bit, including requesting restrictions on the use or disclosure of information, accessing protected health information, amending protected health information, etc. So the question then is, who is a personal representative under HIPAA? Under HIPAA, a personal representative is a person with authority under the applicable state law to make health care decisions for the patient, or in the case of a deceased patient, the deceased patient's estate. So in most of your states, for example, the parents have the authority to make health care decisions for their unemancipated minor. So they would be the personal representative and have the right to access the information for the minor, and you can always disclose information to them if the parent has the authority to make health care decisions. Now, there are some limitations on that. HIPAA says you're not required to treat that personal representative as the patient. That means you don't have to disclose information to them if, in the case of a minor, the minor has authority to consent to their own health care. If that minor has the authority to consent to their own health care, then the parent is no longer the personal representative because they don't have the authority to consent for the kid if the minor can consent to their own health care. if the minor obtains care at the direction of a court or a person appointed by the court, if the parent agrees that the provider may have a confidential relationship with the minor, then in that situation, you don't have to disclose information to the parent contrary to that agreement. Or if you determine that treating the personal representative as the patient is not in the best interest of the patient. Maybe you think that the father is an abuser or might otherwise harm the patient if you disclose the information to the father. In those situations, you can elect not to treat the personal representative as if they were the individual. Let's talk about disclosures to family and personal representatives, kind of wrapping up the things we've talked about. You get a lot of questions about, well, when can we disclose information to family and personal representatives? General rule is you can't disclose information to anybody, can't use or disclose it unless you can fit within an exception. So what are some potential bases? Well, if that family member, if it's a parent and they are the personal representative because they've got the authority to make healthcare decisions, then they have the right to access the information. Not only may you disclose it to them, you must disclose it to them unless you fit within one of those other exceptions. You can make the disclosure to the family member if it's for purposes of treatment, payment, or healthcare operations. You could also disclose it to the family members or others involved in the care of the patient. If the patient did not object, it's in the patient's best interest, and you otherwise limit the disclosure to the scope of the person's involvement, or if you have another HIPAA exception. All right, let's talk about business associates. HIPAA says you may disclose protected health information to your business associate if you have a valid business associate agreement. A business associate agreement, or BAA, essentially is a contract with that business associate that requires them to comply with certain HIPAA requirements. That business associate agreement must contain certain required elements. If you want to check your business associate agreements to know whether or not they have those required elements, send me an email. I can shoot you a checklist on that. Now, the key here is knowing who is a business associate. A business associate is someone that a covered entity wants to create, maintain, or access information on behalf of the covered entity. It's somebody you want to have your protected health information because they're doing something for you. So a business associate would be like maybe your management company, your outside management company, your outside billing company, maybe a consultant, maybe an accountant or an attorney, your malpractice insurer if they're going to get information about one of your patients, maybe interpreters if you're hiring an outside interpreter to come in and help you. Data storage companies. Under the Omnibus Rule, they clarified the business associate requirements also apply to data storage companies. So if you're storing your data off-site at another entity, that data storage company is your business associate, and you need to have a business associate agreement with them. Any subcontractors of business associates are also going to be business associates if they're going to further access, use, or disclose that protected health information. So business associates are those entities whom you want to have your information, to do something with your information on your behalf. Well, who are not business associates? Well, your own workforce members aren't business associates. They're your employees. They're your agents. You can control them. They're part of you. So you don't need a separate business associate agreement with them. You should probably have a confidentiality agreement with them, but you don't need a business associate agreement with them. Other providers, when they're providing treatment, they're not your business associate. They're not doing that for you. They're doing it on their own behalf, so they're not your business associate. Members of an organized health care arrangement are not business associates. That's like the hospital, members of its business, medical staff. Insurance companies, they're not your business associates unless they're performing health care services on your behalf. But if all they're doing is paying claims, well, they're not doing that for you. They're doing that as part of their business. Mere conduits of information are not business associates, like the mailman, the FedEx guy. Yeah, are you going to give them your information? Yes, but you're not expecting them to open the package and read it. Like your janitor, they may come in, they may see your information inadvertently, but you're not asking them to do anything with your health information while they're there. Therefore, they're not your business associate. You'll want a confidentiality agreement with them, but they're not your business associate, so you don't need a business associate agreement with them. Now, the covered entity is liable for the acts of the business associate in two situations. The first is if you knew or should know that the business associate is violating HIPAA, doing something wrong with your information, and you fail to act. In that situation, you can be liable for what they did. actually you're liable for your own failure to act. The second situation is if that business associate is acting as your agent under the federal common law of agency, meaning that you generally have the right to control them, they're doing everything you do because you're telling them exactly what to do. If they're your agent, then you're vicariously liable for what they do. So you want to make sure your business associate is an independent contractor, not an agent. You're generally not liable for what independent contractors do. You may want to make sure your business associate agreement specifies that the business associate is an independent contractor, not an agent, and make sure that you don't exercise undue control over the method or manner of what the business associate does. If you do, if you're controlling every aspect of what that business associate does, that may make them actually your agent. You may be vicariously liable for what they do, and you don't want to be doing that. All right, that's the privacy rule. Let's talk about the security rule. Security rule, a big issue, as some of the headlines recently show. I mean, there's a lot of the data out there online, and there's a lot of hackers out there. The whole purpose of the security rule was to make sure that covered entities put in place certain protections to ensure the confidentiality, the integrity, and the availability of electronic protected health information. It's not only to make sure your information remains confidential, but it's also to make sure that you've got it when you need it. So that if your server crashes, you've got backups so that you can access it and you can keep providing effective care. Or that your data is not corrupted so that you can keep providing effective care. In order to comply with the security rule, you generally have to do the following. You've got to conduct a risk analysis, and depending on the results of that, you've got to implement certain safeguards, certain administrative, technical, and physical safeguards to protect your electronic protected health information, and you've got to execute business associate agreements for those entities with whom you are sharing your protected health information. Let's talk about that risk analysis. The security rule requires that covered entities and business associates conduct an accurate and thorough risk assessment of the potential risks and vulnerabilities of the confidentiality, integrity, and availability of their e-PHI. If you look at the recent violations that have been cited, a lot of those deal with situations where covered entities have not done a risk assessment, or they have not done a risk assessment since 2005 when the security rules came out. The government wants to see you make sure that you're conducting that risk assessment and that you are periodically reevaluating it. For example, if you get new systems or equipment, or every few years, they haven't said you have to do it every year, but certainly every few years you need to do it, and probably more often the better. And you should make sure that you're including your mobile devices. The government has published some very helpful risk security tools on March 28, 2014, I believe it was. They actually published a security risk assessment tool so that you can go on healthit.gov, download that, and it will walk you through your security risk assessment. You can, if you wanted to, you can pay an outside vendor to come in and spend $20,000 or $30,000 to do your risk assessment for you. Some entities will do that. But the government did not necessarily intend for you to have to do that. You can comply with the security rule by using your own, doing your own internal risk assessment. The security risk assessment tool is a relatively easy and free method for documenting and conducting your security risk assessment. The government has given additional guidance on how to conduct that risk analysis on their HIPAA website there on your screen. Okay, so once you do that risk assessment, you kind of evaluated where you are on security rule compliance and what your risks are. Then you've got to implement these administrative, technical, and physical safeguards. Under each one of those safeguards, there's certain standards. And then under each of those standards, there are implementation specifications. Now, some of those implementation specifications are required. If they're required, then, not surprisingly, you've got to implement that specification. On the other hand, if they are addressable, then you don't necessarily have to implement that same specification, but you've got to assess the reasonableness of the specification. If it's reasonable, you've got to implement it. If it's not reasonable under your particular circumstances, then you need to document why it's not reasonable. For example, your relative size, the cost of that factor, the risk factors, etc. And you've got to implement an alternative if it's reasonable. For example, encryption is an addressable standard. The presumption is that you will encrypt your electronic protected health information. But if for some reason that's not reasonable, then you've got to document why, and you've got to implement alternative standards. Your security safeguards, they are not technologically specific. They don't say that you must adopt this particular type of program or this particular vendor or anything like that. Instead, they give you the standards, and you just got to use the means that you want to come up with in order to achieve that standard. You may use measures that reasonably allow you to comply with the standards considering your size, complexity, and capabilities, your technical infrastructure and costs, and the like. So for a large hospital system, they're going to have more requirements than, for example, a solo mom-and-pop physician office. As far as the administrative safeguards, you've got to assign a security officer, implement policies, procedures, and safeguards to minimize the risk, sanction workforce members who violate policies, have a process for authorizing or terminating access to electronic protected health information, train workforce members on security requirements, a process for responding to security incidents, review or audit information system activity, establish backup plans, disaster recovery plans, etc., and periodically evaluate security measures. Your physical safeguards have to include the following. You've got to limit access to your physical facilities and devices containing e-PHI, like using locked doors or things like that. You need to document repairs and modifications to your facilities, secure workstations, implement policies concerning proper use of workstations, implement policies concerning the flow of e-PHI into and out of the facility, implement policies for disposal of electronic protected health information, and create a backup copy of your electronic protected health information. Under each one of those, there will be specific implementation specifications. For your technical safeguards, you've got to assign unique names or numbers to track users, implement automatic log-off processes if the workstation is left unattended, use encryption and decryption where appropriate, implement systems to audit the use of e-PHI, implement safeguards to protect e-PHI from alteration or destruction, implement methods to ensure e-PHI has not been altered or destroyed, implement a verification process, protect data during transmission. Okay? A lot of that is very technical. Fortunately, the government has given you some resources on their healthit.gov website. Let's talk briefly about encryption. As I mentioned, encryption is an addressable standard. It says that you've got to implement a mechanism to encrypt electronic protected health information whenever deemed appropriate. Encryption is important because electronic protected health information that is properly encrypted is deemed to be secured. That means if you lose a USB or a laptop containing encrypted information, well, it is secured, and therefore you are not going to have to report it to the government or to the individual. On the other hand, if you lose an unencrypted laptop or USB, you're probably going to have to report it to the government and the individual, and you could expose yourself to fines or penalties. The government has issued guidance concerning how you go about encrypting your information. They periodically issue guidance. So far we've received one. You can access it at the website that's there on your screen. A brief word about communicating via email or text. The general rule is you've got to have encryption for any data that's in transmission over, for example, the internet. That means to the extent you're emailing protected health information over the open internet, hey, you are not complying with the security rule in all probability. Well, does that mean you can't email or text patients? Well, under the Omnibus Rule, they said you can as long as you tell the patient in advance that that form of communication may not be secure, and the patient says that they want to go ahead and receive it anyway because the patient has a right to receive communications by alternative means or alternative locations, including via email or text. So if you have a policy of emailing or texting your patients, you just want to make sure that you've notified them in advance that that may not be secure, and as long as they agree to it, then you can go ahead and email them or communicate with them otherwise via unsecured internet. Well, what about emailing other providers or texting other providers? Hey, this exception doesn't necessarily apply there. If you're emailing or texting other providers or other entities, business associates and the like over the open internet, you may have security rule issues. You may want to take a look at that and make sure that you're complying with the security rule or change your practices. For those of you who are, your head is spinning because of the security rule requirements, again, the government under healthit.gov is giving you some helpful hints and guides for implementing privacy and security. Spend some time on that healthit.gov website and see what they've got available for you. You can also check out the OCR's HIPAA website where they've got additional security rule guidance that can walk you through some of those steps. When it comes to mobile devices, that is a big risk area. The government has a specific website dealing with privacy and security of mobile devices. You may want to spend some time there just to make sure that you're satisfying the rules with regard to mobile devices. In addition, under the security rule, you've got to document that you have written policies and procedures to comply with the standards and specifications. You've got to maintain that written documentation in electronic or hard copy form. You've got to maintain that documentation from 6 years from the later of its creation or the last effective date. You've got to make the documents available to persons responsible for implementing the procedures and review and update that documentation periodically. I cannot stress enough the importance of making sure that you've got the appropriate documentation and policies in place. If you've got that in place and you just have a rogue employee that screws up, well, that may not be willful neglect. You may be able to avoid fines and penalties because sometimes things just happen when a rogue employee screws up. But if you've done everything you could by having those policies and procedures in place, by providing the training, then chances are, even though there is a violation, there will not be willful neglect. And if you correct it within 30 days, you can avoid HIPAA fines and penalties. Let's talk about patient rights, because HIPAA also gives patients certain rights concerning their health information. Let's talk about each one. First is the Notice of Privacy Practices. As you know, you have to give your patients, if you're a direct treatment provider, you've got to give your patient a copy of your Notice of Privacy Practices no later than the first date of treatment. That notice is a summary of essentially the HIPAA rules and explains how you're going to treat their information. Think of it as a contract with the patient. You're telling the patient this is how you're going to treat the information, and you need to make sure you comply with that. If you disclose information in violation of your Notice of Privacy Practices, that may be a violation of HIPAA. You want to make sure your Notice of Privacy Practice is consistent with HIPAA, so you're not limiting yourself to or preventing yourself from making disclosures that might otherwise be allowed under HIPAA. If you would like a sample Notice of Privacy Practices or a checklist for what your Notice of Privacy Practices ought to contain, send me an email and I can shoot you a checklist. If you're a direct treatment provider, you've got to give a copy of that notice no later than the first date of treatment. If the first date of treatment is via electronic communication, then you're supposed to have it set up so that Notice of Privacy Practices goes out at the same time you have that first contact. You've got to post your notice in prominent locations like your waiting room. You've got to post your notice on your website if you maintain a website. You've got to make a good faith attempt to obtain the acknowledgement of the patient's receipt. So when they come in, you give them the notice and you have them sign your registration form or some other document that notes, yes, I got a copy of the Notice of Privacy Practices on this or another occasion. If you've not done so recently, you should update your notice to include the requirements from the HIPAA Omnibus Rule from 2013. So if you haven't updated your Notice of Privacy Practices since January 2013, you are not compliant. Next right, a patient has a right to request restrictions on the use or disclosure of their protected health information for purposes of treatment, payment, or healthcare operation. Now, for those of you who are actually paying attention and not sleeping, you're thinking, well, wait a minute. I thought that we could use or disclose protected health information for treatment or payment purposes without the patient's authorization. But this gives the patient the right to request restrictions. You're right, the patient has a right to request restrictions, but guess what? You don't have to agree to them. And my advice is don't agree to restricting use or disclosure for purposes of treatment, payment, or healthcare operations because you don't want to create more potential liability for yourself. So even though the patient requests, don't agree to those additional restrictions. If you do agree to the additional restrictions, then it's kind of like a contract. You're bound by them and you've got to comply with them unless it's an emergency or unless there's a disclosure that's required by the regulations. You can only terminate that agreement prospectively. So if your agreement was that we won't disclose this information, you've got to stay with that agreement. You can tell them that for future information, we're not going to agree to that, but you're going to still be bound by your agreement concerning that past information. Again, don't agree to those restrictions. Now, there is an exception to that. Under the Omnibus Rule, if a patient pays for their episode of care, then they can come in and say, I don't want you disclosing that information from that episode of care to my healthcare provider, or excuse me, to my health plan for a health insurer for payment purposes. And if they tell you that, then you can't disclose that information to that health insurer for payment purposes. Now, stop and think about that. How in the world are you going to implement that at your particular facility? That is pretty darn hard to do. The only advice I can give to you is be careful and never ever ask the patient if they want to limit your disclosure of that information. This is kind of a don't ask, don't tell. If you don't ask them, they probably won't request it. If they do request it, then you've got to comply with it. Next right, a patient has a right to receive communications by alternative means or by alternative methods. And you've got to accommodate reasonable requests. So this may be a situation where a patient comes in, maybe she's a battered wife, and she does not want her husband to know that she went to her OBGYN. So she tells you to send her information to her office instead of her home. Or maybe she doesn't want it put on a postcard. If it's a reasonable request, or maybe she wants you to communicate with her via email or text. If that's a reasonable request, you've got to comply with it, and you may not require an explanation of why they want it. Next right, an important right, is the patient has a right to access or obtain a copy of their protected health information, but not all protected health information, only their information that's maintained in a designated record set. Their designated record set is the information essentially that's used to make healthcare decisions concerning the patient's health, healthcare, or payment for their information. It is not information in like credentialing or quality assurance or that type of stuff. That's not your designated record set. It's only the information concerning their healthcare, their payment for their healthcare that are used to make decisions concerning their information. Note that they have a right to access that information no matter who created it. So even if you've got information about a patient that was created by another healthcare provider, if you've got it in there, if it's part of their designated record set, you use it to make decisions concerning them, then that patient has a right to access it from you, and you can't just send it to them to that other healthcare provider. That patient has a right to request that their information be sent to another entity. If you get that request from the patient, you've got to respond within 30 days. If you maintain the record off-site, then there's situations where you can get an extension. You must provide the records in a requested form if it's readily producible, including electronic forms. So if they come in there and say, I want you to download it on this USB, you can go ahead and do that. You may require that that request be in writing, and you may charge a reasonable cost-based fee for that, producing that information. That cost-based fee is the cost of labor and the material of making copies. You can't charge them some kind of an additional administrative or processing fee, particularly if it's going to discourage them from getting that care. You can only charge them a reasonable cost-based fee, meaning the cost of labor and materials in making the copies. So you could charge them if they want it on a DVD or a USB, then you can charge them for the cost of that DVD or USB. If you have a request and there's a question about whether or not you should respond to that request, check with your privacy officer. There are certain circumstances where you can refuse to provide information in response to requests. For example, if you conclude it's not in the patient's best interest, then you can do it if you satisfy certain requirements, but those are pretty few and far between. Generally, if you have questions, make sure you check with the privacy officer. The individuals' access to information is a hot topic right now with the OCR. The OCR recently issued a guidance of about 10 or 15 pages to individuals explaining the right of access. If you haven't called that up and taken a look at that, you may want to do that to make sure that you're complying with the individual's right to access. If you don't, you can get hit up with penalties. One of the largest penalties so far for HIPAA violations was $4.3 million. It wasn't an improper disclosure. It was because the covered entity failed to produce records or grant patients access to the records even though they were required to. Next item. A patient has a right to request amendments to their health information. Note that they only have a right to request the amendment. They don't necessarily have the right to get the amendment made. The covered entity may deny the request if the record was not part of the designated record set, the entity did not create the record, unless the creator is not available. So, for example, if that record was created by Dr. Jones, then you can send that patient over to Dr. Jones to have that record amended. Unless Dr. Jones is no longer available, then you need to act on it. You can also deny the request if the record is accurate and complete. No, we're not going to make the amendment because the record was correct when we made it. You must act on that request within 60 days. If you accept the request, you've got to amend the record accordingly and follow through on certain other things. If you deny the request, you've got to notify the patient of the basis for the denial. That patient has a right to have their request become part of the record. So their medical record now includes their right to request their amendment. If you're going to deny a request, or actually anytime you get a request for amendment, the best thing to do is to check with your privacy officer to make sure that you're complying with all the rules and the regulations that go along with amending those records and following up. Finally, a patient has a right to receive an accounting of disclosures of information that you've made during the prior 6 years. Now you're thinking, what? We've got to log all the disclosures we make of that patient's health information for the prior 6 years? No. Not necessarily. They only have a right to an accounting of disclosures of certain types of disclosures. Generally, it's improper disclosures or disclosures that are made pursuant to 45 CFR 164.512, those government and public safety exceptions. You generally don't have to log disclosures for treatment primary healthcare operations or disclosures per an authorization and those types of situations. You've got to maintain that log of disclosures. That log has to identify the date of the disclosures, the name of the entity receiving the disclosure, the description of the information disclosed, and describe the purpose of the disclosure. You've got to account for disclosures of the business associates. So if you've got your business associate out there who's making improper disclosures, you've got to log that and include that on your disclosure log. If you get a request for an accounting of disclosures, check with your privacy officer to make sure that you can produce that. Now, I suspect that the vast majority, if not all of you, have never once received a request for an accounting of disclosures. But that doesn't exempt you from this obligation. You should be maintaining that accounting log in case you are ever requested to produce it. Now, under the HITECH Act, they actually broadened the right to obtain an accounting to include accounting of certain types of records for treatment payment or healthcare operations if you maintain electronic records and you have certain functionality. We've got a proposed rule on that, but we don't have the final rule on that. We're waiting for the final rule, and that final rule comes out. It may actually require you to have functionality in your electronic medical programs that would allow you to produce a report of all disclosures you make of the patient's information. So just watch out for that. We don't have it there, but it may be coming down the pipe. All right. Those are the patient rights. Real quickly, let's talk about breach notification. Under HIPAA, if there is a breach of unsecured protected health information, the covered entity must notify each individual whose unsecured information has been reasonably believed to have been accessed, acquired, used, or disclosed. So you've got to tell the patient. You've also got to notify HHS. You've got to notify the government. And you've got to notify the media under certain circumstances. If the breach involves more than 500 persons in your state, then you've got to make these self-reports. If you're a business associate and the business associate has a breach of unsecured protected health information, they've got to notify the covered entity so the covered entity can make the report. A couple of points here. The real key when it comes to breach reporting is knowing first whether there's a breach, and second, whether it is a breach of unsecured protected health information. Remember, if the information is encrypted, then it's not unsecured. Right now, essentially, the only way that you can secure information is to encrypt it. For hard copy data, you can completely destroy it, but if you completely destroyed it, I don't know how you could ever have a breach. So the key here is for electronic information, making sure it's encrypted. And then determining if it was unsecured, determining whether there's a breach. Breach is defined as the acquisition, access, use, or disclosure of protected health information in violation of the privacy rules. That unauthorized acquisition is presumed to be a breach unless the covered entity or business associate demonstrates that there's a low probability that the information has been compromised. That is the standard. The breach is presumed to be reportable unless there's a low probability that the data has been compromised. How do you tell that? You have to analyze the following factors, including the nature and extent of the PHI involved, the person who used or received the information, whether the information was actually acquired or viewed, and the extent to which the risk has been mitigated. There are certain exceptions to that. The bottom line here is we are going to cover that in more detail in our webinar on February 18th dealing with responding to breaches. All right, let's talk briefly about administrative requirements under HIPAA. Under HIPAA, you have to designate a privacy and security officer. All covered entities have to have a privacy and security officer. They can be the same person, they can be different people, but they are your HIPAA czars. You've got to train your workforce. So new people who come on, you've got to train them within a reasonable time after they start. If you're making changes in your policies, you're going to want to train them after that. I think it's a good idea to periodically conduct training. That's why we're doing this session today. Because if you show that you have trained your people, you've got the policies in place, and they violated that, then you can probably avoid willful neglect penalties. You've got to implement written policies and procedures. The policies and procedures we talked about. If you're wondering what is a checklist for policies and procedures, send me an email. I can send you a checklist of the policies and procedures for privacy rule and security rule. You've got to respond to complaints and violations and document your responses. You've got to mitigate improper disclosures. You've got to maintain required documentation for 6 years. That's not your medical records. It's the things like your notice of privacy practices, your business associate agreements, those types of things. And you've got to implement reasonable safeguards. What are reasonable safeguards? Well, we know what they are under the security rule. Under the privacy rule, not nearly as specific. They just have to be reasonable safeguards. Now, reasonable safeguards are important because if you have an incidental disclosure and you've otherwise got reasonable safeguards in place, then that incidental disclosure does not violate HIPAA. Sometimes people just overhear things, but as long as you have reasonable safeguards in place, that disclosure is incidental to an appropriate use, that is not a violation and it's not reportable. What are reasonable safeguards? Well, you're not required to remodel, eliminate sign-in shades, isolate x-ray boards, that type of stuff, but you should do reasonable things like keep records, monitors, faxes from the view of unauthorized persons, take steps to minimize eavesdropping, so don't be blurting out protected health information out to your entire waiting room. Supervise or lock areas where records are stored. Use passwords. Avoid patient names in public. Those types of things. All right. That is a brief overview of the HIPAA privacy and security rules. Now, in closing, I just want to go through a few action items. You're sitting there wondering, okay, what do we need to do to make sure that we're compliant with HIPAA? What's our quick checklist? These are my top 10 items you need to do to make sure you're compliant, that you're not going to get hit up with willful neglect penalties. First, make sure you assign and document HIPAA responsibility. You've got to have your written designation of your privacy officer and security officer and make sure they know what the rules are. 2, well, ensure the officers understand the rules. There's no substitute for actually opening and reading the rules. 3, review your security rule compliance. As I mentioned, that's the big ticket exposure these days. Conduct and document your security risk assessment. Make sure that you've got the required policies in place and beware electronic devices. 4, ensure you have the required policies under the privacy rule, security rule, and the breach notification rule. If you would like a copy of those privacy and security checklists, just send me an email. I can send that to you. Number 5, develop and use compliant forms. Forms that satisfy the HIPAA standards, including your HIPAA authorization, your privacy notice, maybe patient requests for records, although that's not required. It's a good idea to have those types of things. Number 6, execute valid business associate agreements with business associates. Follow up if there are problems with the business associate. Remember, you're generally not liable as long as they're not your agent, and you take prompt action if you know that they're messing up. 7, train members of your workforce and document their training. Train them upon hiring and periodically thereafter. Number 8, use appropriate safeguards like confidentiality agreements with workforce members, reasonable administrative, technical, and physical safeguards to protect your information. 9, if you think that there is a potential breach, immediately respond. Take steps to mitigate. Retrieve the information that was improperly sent or disclosed. Obtain assurances that there will not be any further use or disclosure. Warn the persons who received it of the penalties of violations. Investigate the facts to determine if there was a breach. Sanction workforce members as appropriate. Implement corrective action, additional training, etc. to show that you took appropriate steps to correct it, because remember, if you didn't act with willful neglect and you correct it within 30 days, no fine. Document all of the foregoing. And 10, if It is a reportable breach. Make sure you timely report those breaches as required by the rule. We'll talk about that in a couple of weeks. Additional help, if you need more help on HIPAA stuff, the government maintains an extremely helpful website from the Office for Civil Rights. Just Google OCR and HIPAA. It'll take you to the website. It's got lots of resources, FAQs, some forums, lots of other stuff. That should be your first resource, if you're not going to call me, if you have HIPAA questions. In addition, on our website, we've got a bunch of information. I do a lot of HIPAA stuff. We've got webinar recordings. We've got articles, forums, checklists. You can access that by going to our healthcare website, and you can get a whole bunch of stuff, and the best thing, it's free. Future webinars. Next week, one of my colleagues is going to be talking about HIPAA for Business Associates on February 18th, 2 weeks from now. I'll be back talking about responding to HIPAA breaches. If you would like to sign up to get notice of those webinars or get our publications we send out periodically for free, feel free to shoot us an email. We'll sign you up for that list. And I think that that is it. We went a few minutes over, but I hope that this has been helpful. Again, feel free to use this if you want to conduct training for your organization and document that training. Hopefully it will allow you to get on the right track for your HIPAA compliance. Good luck and have a good day.